Ladies and gentlemen, thank you for standing by and welcome to the BIA Knowledge Leadership Series webinar. During the presentation, all participants will be in a listen-only mode. If you would like to ask questions during the presentation, please use the chat feature located in the lower left corner of your screen. If you need to reach an operator at any time, please press *0. As a reminder, this call is being recorded Thursday, October 15, 2015. I would now like to turn the conference over to Robin Thompson. Please go ahead, ma'am.
Hi, everyone. On behalf of our team here at BIA, thank you for attending our October Knowledge Leadership Series webinar, where our experts are going to talk today about the ethics of legal hold. We've got a lot to cover today, so I'm going to move through our housekeeping slides fairly quickly. As Carlos indicated, please send your questions for the speakers through the chat window, and we'll get to those at the end of the program. And a note about certificates of attendance and CLE. For those who are self-certifying your CLE in states with verification requirements, we're going to provide 3 numeric verifiers during the program, and you'll be asked to supply those at the end of the program in the survey, and then we'll send you documentation back. As we indicated, CLE All Ethics is pending in the state of Texas, and we'll send information out about that. Everyone on the call will automatically also receive a certificate of attendance for reporting other types of CLE credit. This is my favorite part of the program, and I promised our speakers today that I would not do lengthy introductions because we're going to supply you with their vitaes in the handout materials. But with us today, we have Brian Schrader, a licensed attorney and technologist who is currently president of BIA, and Barry Schwartz, also a licensed attorney and certified e-discovery specialist who is VP of BIA Advisory Services. And with that, Brian, I turn the program over to you.
Well, thank you, Robin, and thank you, everybody, for joining us today. We've got quite a big crowd. This is one of our most popular webinars, so we hope to get through and have some time towards the end to answer your questions. So with no further ado, let's go ahead and get started. This is just a quick little roadmap of our discussion, let you know what we're going to talk about. First, we're going to go over a little bit of history. Why are we talking about legal holds in the context of ethics specifically? Then we're going to talk about the legal holds in the FRCP as well as the model rules. Then we'll talk a little bit about case law and sanctions. We won't spend a whole lot of time on case law. The details will be in the packets that you'll receive if you fill out the survey. And we really want to get some time to spend on the practical guidelines. So without kind of belaboring that point, let me go ahead and get started on the first topic, which is really the history. Where did we get here? Why are we talking about the legal holds in terms of ethics? First question I always start whenever we talk about legal holds is make sure we're all on the same page. Because some people, when they talk about legal holds, will wrap in issues of custodian questionnaires and actual data collections and things like that. And while that's all kind of the part of the preservation process, we're really focused on legal holds, which is the idea of sending out this notice to potential custodians, or the rest of the world calls them employees usually, to tell them to preserve information regardless of format in anticipation or in response to a litigation. So that's what we're talking about today. So the big question becomes, how does this, well, actually, before we get to the question about ethics, the question really I get asked by a lot of people is why are legal holds in such focus? Why has everybody kind of really focused on whether or not legal holds are being issued and how they're being issued and who's issuing them? Really, I kind of say that there's 2 cases in the vast catalog of e-discovery out there that really kind of put nice bookends. Of course, the Zubila case back in 2003, I think you can't be in e-discovery without fully understanding those cases back in the day. There was a whole line of cases, but the Zubila 4 case really talked a lot about preservation. And it talked a lot about preservation, talked about litigation hold notices and then on into preservation and what a company should do. And that really kind of kicked off a lot of those discussions, a lot more detailed discussions around exactly what a company is expected to do when it comes to preserving data and issuing legal holds. And then in 2010 is really kind of the next huge milestone I saw and what really kicked off, call it the modern focus on litigation holds, in my mind at least. That was the case where Judge Scheindlin came out and said that if you didn't issue a litigation hold in writing, it was de facto negligence, essentially. And although the case was later, that specific holding was later overturned by the Second Circuit, or really not overturned, but rejected because it was a separate case, it still focused everybody pretty intently for a period of time on litigation holds and the notices themselves and the process for doing it. And really sparked that conversation that brought it back to the highlights. So I think those are kind of some of the reasons why litigation holds are in such focus. Everybody talks about them. The other big reason is because it's probably the single most important thing you'll do in a case. There's not much other stuff in e-discovery that you can do that if you mess it up could result in sanctions across your entire case. You could, companies have lost cases for not issuing sanctions or legal holds, and we'll talk a little bit about that when we get into the case law. So it is a very, very important part, but it's also been a part of a lot of rulings over the last couple of years that have really focused people's attention onto it. Now, that being said, why are we talking about it in terms of ethics? Well, we're talking about it in terms of ethics because courts have started being much more vocal about outside counsel and inside counsel, but really outside counsel's role in making sure that litigation hold notices or legal hold notices are issued, that they're issued correctly, and they're maintained correctly, and they're placing that responsibility at the foot of counsel. So the cases you see here, the Palmeroni case was the first one really that caught our eye, that really focused us in on this and kind of kicked off this whole webinar series that we refresh every year now. And it was because the court specifically in that case went out of the way to fault outside counsel. And while the court didn't sanction outside counsel directly, it did pretty much tee up kind of a malpractice issue, saying that the attorney there had kind of ignored their responsibility by just kind of letting the CFO of the company take over the discovery process, and specifically really the legal hold process. The Suarez case was an interesting one as well because it faulted the Attorney General's office, or the U.S. Attorney's Office, for failing to issue a litigation hold notice to the FBI. This was one of those things, when I first looked at it, it was kind of remarkable on its face to me, because you would assume, number one, that the FBI would know how to maintain evidence, and that, number two, they wouldn't need to be really told by the DOJ attorneys that they needed to preserve that evidence. But they didn't, and the FBI in this particular case didn't maintain the evidence, so it resulted in sanctions in that case. And it was very interesting to me that it's not just in civil litigations that it comes into those type of cases, and criminal cases potentially as well. There are a couple other cases. In the Malik case, the court there was really looking at affirmative duty to preserve emails because of that particular firm's representation of a client on a transaction. And that transaction eventually turned into litigation, and the firm hadn't done anything about preserving their own records. So it was a little bit different than some of the earlier cases I was talking about, but it shows that this obligation extends to attorneys in all different ways. The Pantheon case was really remarkable. It came out last year. It was remarkable to us because, as you can see here, the court not only sanctioned the plaintiffs and counsel, but it specifically recommended that the firm, quote, explore which attorneys caused or helped cause this discovery failure and determine whether those attorneys, rather than the firm itself, should pay all or some of the sanction. And so that was probably the most aggressive that we had seen on this issue today, and really laid at the doorstep that not only can you sanction outside counsel, but you could also you see the court go to look for specific attorney liability. And then in the Tellermate case was a recent case as well, where the court was faulting outside counsel for their failures in e-discovery, and their failures there not only around litigation hold, but around identifying documents and evidence as well. So that's really kind of where we got and how we got there, and why we're talking about this today in terms of ethics, because the courts have made it a responsibility. And Barry will now kind of go through the FRCP and some of the model rules to show you where the intersection in those two groups of laws really kind of lay the basis of ethical issues for counsel, both internal and external. Barry.
Thank you, Brian. Excuse me. Just as a preface for everybody on our presentation today, there is a series, I'm sure most people are aware, a series of amendments to the federal rules that will be in effect as of December 1st of this year. And let me talk now specifically regarding Rule 26 and its impact on the ethics of legal holds and discovery itself. On discovery productions, the certifying attorney better know what it is they're signing off on. That is that in G1, the disclosure that is completed for a court certifies that the signer is signing off with the knowledge that what it is that they're signing is true, correct, and accurate. And if the attorney who is certifying to a production violates the rule, there is a clear possibility of sanctions. And Rule 37E is the one of the modified, amended rules that is receiving the most attention. The prior rule is crossed out in the crosshatch here, and essentially it provided for a safe harbor if electronically stored information was lost through the routine good faith operation of an electronic information system. Now, the new rule provides that the court, upon finding prejudice to another party from the loss of the information, may order measures no greater than necessary to cure the prejudice. This proposal preserves broad trial court discretion to cure the prejudice caused by the loss of ESI that can't be remedied by restoration or replacement of the lost information. And the rule also does clarify a split in the circuit courts and states clearly what is sanctionable and what is not. And the ABA has also written about this, saying that they think the rule would apply to all forms of discovery, and that there is no bright line with respect to what is right and what is wrong. There are a couple of cases that we'll talk on a little bit later, but one in particular, L&L Painting, is a case that followed the Chin decision, and it was rather prescient in the fact that this is a slip decision that was issued last fall, and in that case there was no litigation hold. It was citing Chin for precedent, and a custodian's data was lost. However, through other means, other custodians, the data that was lost was relocated, and hence the court determined that because whatever was missing was now again found, though not with that custodian whose records were spoliated, no harm, no foul. And then just this morning, Law 360 published an article regarding the U.S. Versus Dish Entertainment litigation, and there they found, or they reported that Dish had lost a hard drive that had records on it for a particular set of documents, and Dish was able to locate similar records provided to someone else that were virtually identical to what was missing. So the judge wrote, the court recognizes that this data is not a representative sample, but the question before the court is the appropriate proportionate sanction. And the judge went on to write, finding that Dish sent and received communications of a similar type and quantity with other companies, hence that's a remedy. So the prejudice, there is no remedy, or there is no prejudice against the company, and hence that is an appropriate and proportional response. And to summarize, from the committee excerpt, The present amendment restores the proportionality factors to their original place in defining the scope of discovery. This change reinforces Rule 26G, which is the obligation of the parties to consider these factors in making discovery requests, responses, or objections. And Judge Grimm has recently pointed out that the rule encourages cooperation, and particularly with respect to discovery plans and as well as to proportionality. And he went on further in a recent presentation to discuss what he thinks are the 4 pillars within the new rules. Cooperation, judicial involvement in active case management, which goes to the issue of discovery orders and so forth, proportionality, and then also equally important is the duty to preserve and the ability for the court to impose related sanctions. And I'd like now to discuss some of the ABA model rules because they dovetail nicely with the federal rules. The first rule I want to discuss is 1.1, that of competence. A lawyer shall provide competent representation to its client, and competent representation requires legal skill, knowledge, skill, thoroughness, and preparation. And just this summer, the State of California Bar Association issued an interim opinion that states very clearly that depending on the factual circumstances, a lack of technical knowledge in the handling of e-discovery may render an attorney ethically incompetent to handle certain litigation matters involving e-discovery absent curative assistance. And what does curative assistance mean? That you have, if you don't know it, have somebody on your team who is extraordinarily competent in litigation holds, e-discovery, and so forth, so that you have a team of competent people representing your client. And Model Rule 1.3 regarding diligence is what it is. A lawyer shall act with reasonable diligence and promptness in representing a client. In Model 3.4 regarding fairness, where a lawyer shall not unlawfully obstruct another party's access, falsify evidence, knowingly disobey an obligation under the rules of a tribunal or court, or make frivolous discovery requests, and so forth. And from this rule, it can be inferred that if you fail to ensure a legal hold has been properly issued, then you may be seen as obstructing another party's access to evidence. And this Rule 1.13, remember that when an attorney is representing an organization, the organization itself is the client. Not the GC, not any of the employees, but the organization itself. So if the GC tells you they don't want to issue a litigation hold, then the rule indicates that you can't stop there. You need to escalate that issue up to a more senior person within the organization to make certain that your legal advice that a legal hold should be issued is indeed being followed. And another corollary to this rule is that it's the reason why when a corporation faces legal scrutiny, say the VW issue right now, you can be assured that executives that are targeted for investigations as well also have different representation. And then, pardon me, when you're working with other attorneys in your organization, it's your responsibility as a supervising attorney to be certain that they are as well following the ethical rules. So as a supervising attorney, you're responsible for your team members working for you, that they too are performing ethically, appropriately, and competently. And if not, the risks fall on you as their supervising attorney. And as I mentioned in talking about the model rules, this Rule 5.1 dovetails really nicely with the Federal Rule 26 regarding certification of discovery productions, where the certifying attorney is signing off that what they have done is correct, true, competent, and so forth. And 5.2 talks about if you're in the role of being a subordinate attorney. And I think it goes without saying that if you're an attorney, you're also bound by the rules of professional conduct. There is a minor caveat here that a subordinate lawyer does not violate the rules of professional conduct if that lawyer acts in accordance with a supervisory lawyer's reasonable resolution of an arguable question of professional duty. And then Rule 5.3 ties in with what Brian was speaking about regarding NVE versus Palmeroni. That if a lawyer is dependent on non-lawyers, such as in the Palmeroni case, the CFO, it falls back to you, the lawyer, if something is done or not done that should have been done in order to further your legal or ethical obligations. And to that, I'll turn the presentation back to Brian for a discussion of some of the current case law.
Well, thank you, Barry. So hopefully up to now you've seen that the importance of a litigation hold in general and how those tie in with the Federal Rules of Civil Procedure. We talked about the terms of federal in terms of the federal rules and in terms of the ABA rules, because those are the rules under which courts have started finding counsel liable for e-discovery or for litigation hold issues and failures. So hopefully you've seen where some of those kind of liabilities or really ethical obligations can come from, especially obviously probably the one that's most applicable to the entire process is the competency and the due diligence requirements that are basic requirements in ethics. So that all being said, we're now going to focus on how to issue legal holds, how to make sure you're doing this right so you don't run into any of those problems. And the way we like to start that out is to start just quickly go through some case law that talks a little bit about some more recent rulings in this area. Not meant to be completely comprehensive. There are entire books out there that people publish on the topic of litigation holds. This is just some of the highlights of case law. We're going to spend most of our time at the second half of the hour talking about the practical applications and how to make sure you're doing this process correctly. But before we get there, a little bit of background on some of the most recent case law to really bring everybody up to date. So that being said, my first example here is as you can see from the headline, the takeaway of the case, in my humble opinion, is what's good for the goose is good for the gander. And the reason I give it that title is that it's essentially that's what it ends up. The ruling ends up telling us as attorneys that. You call it those who live in glass houses shouldn't throw stones, whatever you want to. A million such sayings from my childhood come to my mind. But the idea behind this was, I'm assuming everybody, unless you've been living under a rock, have heard about the Apple and Samsung IP litigations. It's the billion-dollar judgments plus that Apple has been getting against Samsung for violating their patents. Before all of that went to trial, a couple of months before trial was supposed to start, Apple filed a motion for sanctions against Samsung, saying that they hadn't issued a legal hold, they hadn't preserved documents, they hadn't really done anything, and they were able to do this by basically showing big gaps in the information that they had received during discovery, saying that they didn't have information on executives and other important people. And it came out during the whole thing that Samsung actually hadn't ever stopped their automatic data destruction policy. I think their email retention was something incredibly short, like 7 or 14 days. I don't remember if it was a week or 2 weeks, but it was really, really short. They never suspended it. And as a result, there was a lot of information that was lost along the way. And even though Samsung had issued a litigation hold at one point, they hadn't done so until after the case had been originally filed. So there were a lot of great issues in this case. I highly recommend that you read these two cases, these two decisions, because it goes through a lot of great points about how to issue legal holds, how to make sure you're hitting the right people and have the right methods and contacts and when to do it. Trigger events and things like that, which we'll talk about in the next section. But it's a great case, and the first ruling came down and found that, yes, Samsung hadn't issued a litigation hold on time, and in addition to that, even when they issued a litigation hold, hadn't stopped automatic destruction policies and other stuff, so hadn't really made sure that it was being practically applied in practice as well. And so the court issued an order that the jury instructions would be given telling the jury that Samsung failed to preserve evidence and that the jury may presume that the evidence would have been harmful to Samsung or would have been helpful to Apple. And so that's a pretty significant finding. That basically says you can assume there was proof that everything Apple says is true, essentially. So it was very much an Armageddon or a kind of end of the case ruling for Samsung. But they went back to the court and said, wait, and this is where the little saying comes in. Yes, we screwed up, maybe, or actually they said, well, they disagreed with the magistrate judge's findings that they hadn't acted properly. But basically said, even if we did, neither did Apple. Apple didn't issue a litigation hold until way late in the process, and there were missing gaps of information from executives, including Steve Jobs and others. And so the district court judge came back and said, okay, well, basically neither one of you did a good job, so we're going to tone down the adverse inference instruction to the jury, but we're going to give the same instruction about both of you, and kind of facing mutually assured destruction, neither one of them went forward with that ruling. But it is not only is it stand very well for the idea that these requirements apply as much to plaintiffs as they do to defendants. But it does, like I said, go through a lot of great information about the technical aspects of how to issue a legal hold when a triggering event happens. And in this particular case, the triggering event, the court settled on, although there was a lot of kind of back and forth between the companies, obviously, before they filed a lawsuit. At one point, Apple took a whole gaggle of attorneys. I'm not sure what you call a group of attorneys, so I'll call them a gaggle of attorneys, off to Samsung's offices, sat down, and gave them a PowerPoint presentation showing them, here's all the places that we think you're violating our patents, and if you don't stop doing it, then we're going to sue you. And the court latched onto that. It was, I think, 6 months or so before the actual litigation was filed, and they said at that point in time, everybody pretty much knew that a litigation was coming, and they should have started issuing litigation holds at that point. So I spent a lot of time on this particular case, but it's a great case. It's a great ruling. It's got a lot of great information in there, and I highly recommend you go through and read it. A couple of other quick things we'll go through here. Won't spend as much time on all the rest of the cases. This Baker Community Health Systems case is very interesting because it was a case where spoliation claims were spoliation claims were made against the plaintiff, and the court sanctioned the plaintiff for not issuing a legal hold on time, and as you can see, all the other language there. But the interesting part of this is so many of our clients and so many people we talk to out there about these issues are concerned from a defendant point of view. But it's important to understand that it's not just for defendants. Plaintiffs just as much have the same obligations, even though people don't quite pay attention to that as often as they should. It is important that if you're going to be held to a standard, you hold your opposing counsel and the opposing party to the same standard. Now, the other thing is, when you see litigation holds not being filed or not being followed properly, there's not a bad faith requirement. Now, this gets into the whole issue of the federal rules, the new rules that Barry went over, and kind of balancing that there are ways around it. But the idea here is that you don't necessarily have to have, had bad faith to have any kind of sanctions. Now, some of the more serious sanctions that are outlined in the new rules do require some kind of intentional act or willful act. But that's for the more serious sanctions. It doesn't mean you're not going to get sanctioned at all. In case Barry cited, there was a sanction there, although it's not the sanction that the opposing party would have liked. And the other interesting thing about this case is it involved paper, too. A lot of people think that the document retention stuff is only concerning electronic documents because that's what we all focus on today. But in this case, they had not taken steps to preserve documents, basically resumes that had been filed and people who hadn't been hired. Those resumes were purged after a couple of months. This case had to do with their hiring practices. They didn't take the steps to preserve the paper, and so the court sanctioned them for that as well. So don't forget, when you're talking about this stuff, it's not just ESI. Next one is this JP Morgan case. it's an interesting case because the J.P. Morgan had been contacted by the E.E.O.C. about some complaints several times, had correspondence back and forth, but nobody issued a litigation hold. And so documents were destroyed, and the court eventually sanctioned J.P. Morgan for the failures of maintaining the documents there. And what it really comes down to, the interesting thing about this is, you got to make sure that within your organization, you identify sources where triggering events could be identified. That might be in the HR department, it might be in the legal department, it might be in even in sales or marketing or product management or product support. If you're in a medical device company and you start getting lots and lots and lots of complaints, then about a particular product, then it should make sure that rises to the level of review by counsel. And so the idea behind this really is just to make sure that you're looking within your organization at where complaints could come in against the company, against your organization, and figure out, make sure you train those individuals to bring those issues to the attention of the general counsel's office, and make sure that everybody understands when you have events like this that it does give rise to a litigation hold. It's not just when you get served with litigation or somebody threatens to sue you, an E.E.O.C. complaint, which essentially is the beginning of a legal process in this case, can trigger that as well. These two cases really kind of stand, well, the Zubelet case is wide-ranging. It talks about issuing a legal hold when litigation is reasonably anticipated. In the Major Tours case, the litigation hold letters weren't sent out for more than 4 months, and the court found that to be way too long. And we'll talk a little bit about this issue as we go through and talk about how to issue legal holds. But essentially, the basic idea is just get the litigation hold out there as soon as you can. And as we'll talk about in a minute, you don't always have to be perfect. You don't have to, just because you put a litigation hold out today doesn't mean that you can't go and send an amended one in a week. You're much better off getting a notification out there as quickly as possible to the best of your ability. You can always change it, you can always modify it, you can always adjust the custodians and things like that later. But if you delay too long, and there's no bright line rule, it's not like you got 2 weeks. It's a reasonable person standard. So, one court might find one thing and one court might find another as far as what's reasonable. But you really just want to get it out there as quickly as possible, and that's what these cases, especially the Major Tours case, talks about. One more case to talk about. And on the handout, I think we have a couple more cases that we cite as well, but these were ones we wanted to talk about. This one's a really interesting one. The court imposed sanctions here because in-house counsel didn't really take proper steps to identify the right custodians. It was just the court found that there were several critical witnesses that just weren't included in the process. And so it really comes down to the issue of how do you identify custodians, right? How do you know who to put on that list? And we'll talk a little bit about that, but it's very important that you be comprehensive. You can be sanctioned if you send out a litigation hold notice. I guess all of this stuff kind of talks about how not only you need to send out the litigation hold notice, but if you don't do it right, just the fact that you sent it out doesn't really get you very far. You got to make sure you're taking the right steps. And so that all being said, here comes hopefully the most interesting part for everybody, and hopefully you'll see how we've teed up a lot of these issues as we talk through it. Barry and I will both be talking on this topic, which is the practical guidelines. In other words, how do you issue a legal hold in a way that that you're going to hit all these highlights, you're going to hit all these requirements, and you're going to have a defensible process. So as with anything else when I talk about e-discovery, before you get into the actual topic of how to issue a litigation hold, I always like to talk about this one slide first, which is if you want to do all this stuff right, the way to really do it is you got to prepare. You can't just face this the first time you find out. If you do that, and this goes across e-discovery period, not just litigation holds, but data collections and processing and everything else. If you don't plan ahead, if you don't put a process in place, especially if your organization tends to get sued more than a couple of times a year, or more than once a year, really. If you don't put a process in place, put a team in place to handle this stuff as it comes forward, you're going to vastly increase your risks, because you're going to be shooting from the hip the whole time. And probably more importantly for some of us, you're going to drastically increase your costs. And so the very first thing we always talk about is how important it is to create a good offense. Plan and prepare for the eventuality of a legal hold, but plan and prepare for the eventuality of e-discovery, period. How do you do that? You create an event team. You get the right people, inside resources, external resources. You want to make sure that team is educated. You want to have that team create or select solutions around the various issues. In other words, how are you going to issue legal holds? Is it going to be emails and spreadsheets, which is fine if that's what you want to do, or are you going to select a software solution to handle that process for you? How are you going to do collections? How are you going to identify information? All of these things, walk through the process of the EDRM and figure out how you're going to at least take care of the first stuff on the left-hand side, which is where really corporations have kind of taken the control of the legal hold, the data collection process, and even some of the initial filtering as well. Make sure you figure out how you're going to do that, whether it's with a vendor or a software solution or whatever. At least have an idea of what you're going to do. And make sure you assign responsibilities, the key ones, right? Who's going to identify custodians? When that litigation comes in, whose responsibility is it to go through and figure out who the custodian should be? One of the most important things, and that should be somebody who's identified in advance. Who's going to actually issue the process? Who's going to maintain the litigation hold? Because we talk in a minute, it's not just about sending out a notice or putting something on a bulletin board. It's a very dynamic process, and it has to be maintained throughout the entire litigation. And finally, you want this team to be prepared. You want them to know what kind of potential ESI resources are out there. And so you want to have a basic idea. It's not like you have to understand that Mary in accounting uses Evernote on occasion to keep track of her to-do list. No, but you need to know that the organization uses Salesforce, or that the email system is Office 365, or whatever the case may be. Know the big things. Understand what the basic landscape looks like. Trust me, if you do this, you'll decrease your costs drastically. That being said, let's talk about the specifics of legal holds. And the first question there becomes the triggering event. And people, this is the most common question we get asked is, well, how do we know when to issue a litigation hold? I always like to tell people, well, if you're asking me, chances are you probably have to do one already. Because the answer is anytime a litigation is reasonably anticipated. And this is a Supreme or a Second Circuit case here that's cited, but it's a long-standing understanding that you have to issue a litigation hold once you have a reasonable anticipation of litigation. And what we always tell our clients, if in doubt, if you think you might have to issue a legal hold, chances are you do. There is no specific rule on litigation holds. There's stuff that talks about consequences of not doing it, but there's nothing in the federal rules that says here's how you do it or here's when you have to issue it. So it's very much a common law ruling. And some of the examples here are triggering events. Barry, I know you work with a lot of companies. You want to give some examples of the types of things we have here?
Certainly. Thank you, Brian. Product complaints. If you hear about a product that's failed and it's created an injury of some sort or alleged injury, that is certainly a triggering event. The same with product malfunctions. Harassment complaints are a big area where the question is, when does a hold need to be issued, and obviously to whom as well. As soon as your HR department or a responsible person within the organization hears of a harassment complaint, that is the time to issue a litigation hold. And it can be it can be a very obscure matter, such as I'm getting annoyed by such and such a person, and the supervisor should inquire regarding that to see if that does raise to the level of needing to be considered a triggering event. Intellectual property matters are a very typical area where the hold is required long before any litigation is filed. As Brian discussed at some length, the Apple and Samsung matter, Apple knew way in advance that they were going to pursue Samsung. If you're getting ready to file a claim of infringement against some of your assets, that's when you need to consider issuing a litigation hold. And conversely, if you're on the other side of a IP matter, the first inkling that you have that a patent holder is pursuing you for a potential infringement claim is when you need to investigate whether or not it's time to issue a hold. And I think accidents are clear. Claim letters from attorneys regarding an alleged claim from a client to corporation's customer service or legal department is certainly a tip-off. And as soon as you are notified of a regulatory investigation, that's a time to issue a litigation hold. So we have...
Okay, thanks.
you want to do this, Brian?
Oh, do you want to... Well,
no, you can go.
Sure.
Go for it.
Okay, well, I'll go ahead and do it then. All right, so steps to legal hold. So now that you know there's a triggering event, let's take the easiest one. You got served with a complaint, so you obviously know that there's a litigation there, and you got to send out a legal hold. So how do you do it? Well, obviously the first step in issuing a legal hold is figuring out who needs to get it. And so you have to identify your potential custodians. This is probably one of the critical. As you remember, there was one of the cases that we did here earlier, focused specifically on the particular issue and sanctioned the party there for not getting it right or not doing an adequate job. So how do you do it? You cast a wide net, but you don't want to send a legal hold notice out to the entire company. Why is that? Well, we've all heard the story of the boy who cries wolf. And so if your practice is every time you get a legal matter that you send a notice to the entire company, say, hey, don't delete anything, it's going to be seen as a lackluster effort. It's going to be seen as something that becomes the boy who cries wolf scenario, right? Your employees just aren't going to pay attention over time. And so you want to make sure, you want to be clear that you're not just paying lip service to this idea, that you're actually going through and trying to figure out which of the employees, or even, as it says here, third parties might be responsible. So as the case here, the Haskins case, this particular step, identifying custodians, isn't necessarily just within your organization. If you have contractors, especially in this new, the whole gig economy thing, where so much of the workforce is becoming 1099 employees and independent consultants, if the data that person holds is under your custody and control, let alone possession, but your custody or control. And most contracts I sign these days, if I'm signing them with someone who I'm getting data from them, there's a clause in that contract usually somewhere that says their data is still theirs. If you go back to the TellerMate case that had to do with the Salesforce, that issue came up there. The court claimed they couldn't, or the attorneys claimed they couldn't get anything, but the contract itself with Salesforce said that data in Salesforce, their data was theirs, and so they had complete control over it. So it's a big issue. You can't just look inside your organization. You have to look at other third parties, not only people but systems as well. Figure out what you might have to do there. Step 2 is compose the legal hold. We're going to walk through some of these in a minute. Then you want to distribute the legal hold. You need to maintain that legal hold. In other words, you can't just send it out and forget about it. You got to make sure that you're reminding custodians on a regular basis, and then, of course, keep an audit trail. So let's go into each one of these topics a little bit more. I already went in a little bit in detail to the first one, which is identifying custodians. Here's a little more detail on it. Start with a complaint. Look at the people who are there. Then talk to the people you know about, managers, custodians, whatever. One of the questions that you should be asking custodians you put on legal hold right away in a questionnaire or right to their face is, do you know anybody else? Easiest question in the world, and everybody forgets about it. Ask the custodians you identified to themselves, say whether or not they think they have any information, so at least understand what their belief is. But just as importantly, do they know anybody else who should be involved in this litigation hold? Again, don't be afraid. Get it done now. You don't have to be a perfectionist. The courts would much, much rather you being proactive and quick than perfect. No one ever expects, at least judges anyway, don't expect perfection. Realize that people are going to be human and they're going to make mistakes, that nothing's going to be perfect. But sitting by trying to figure out, and we've seen companies do this in the past, go for weeks and weeks and weeks trying to figure out what their custodian list should be. you know who at least the core custodians are, and you know who maybe secondary or maybe kind of fringe custodians are. Get the legal hold out there. You can always let people off the legal hold notice. You can release custodians. You can add custodians. You can adjust the notice itself. Nothing has to be perfect. Get started right away, and especially with the custodians themselves. Don't forget about exiting employees. I know, Barry, this is one of your favorite topics, so I'll let you talk about that.
Oh, thank you. Exiting employees are a critical aspect of most litigation today. I mean, with the mobile workforce, average job expectancy is less than 5 years for employees. People are moving from job to job, and what happens when they leave is they have computer assets of some sort or another, and IT wants to repurpose those assets as soon as possible. But it's important for, as part of your litigation management strategy, to have in place a system that notifies the IT department, HR, and so forth, so that they are notified when an exiting employee is on legal hold, so that their assets can be properly captured by the IT department, so that any information that might be subject to the hold is properly preserved. And that goes without saying
really
throughout.
Sorry, Barry, I was just going to add really quick that this is something that we see organizations really focusing on today, like how do we prevent the data loss that's supposed to be on hold. And what we're seeing a lot of organizations are doing in the software solutions they're using, what you were just talking about, which is creating an automated process where when somebody leaves the organization and their HR system tracks that employee is exiting, it automatically checks to see whether or not somebody's on legal hold and lets the IT department know. So it's an area that we're seeing a lot of automation around today, and we're helping our clients with that because it's so important, and it's something that should be mechanical, really. It should be easy to raise those alerts, but it's been a historical big black hole for companies.
Brian, Barry, I just wanted to give a quick announcement. We're about 10 to the top of the hour, and I just sent out a broadcast thanking you guys. We've got about 10 questions in queue, and we will stay and answer them as long as you guys are here with us.
So that means we're getting paid a little overtime, huh, Robin? Well, I think we've got about 5 minutes left of the presentation. So we'll have 5 minutes to answer questions in the normal hour, and then, of course, kind of like a little bit of overtime there.
NFL overtime
for people
here.
Who want to stick around.
Yeah.
Yes, exactly. Really quick, imposing the litigation hold is the next topic. And really, the question that people always say is, does it have to be in writing or doesn't have to be in writing? And the simple answer to this is just put it in writing. You see all the cases up here that talk about it. Judge Scheindlin said in the pension committee case that it was gross negligence if you didn't write it. And then the Chin case in the Second Circuit said that they rejected that notion. And so many people looked at the Chin case and said, well, the Second Circuit says it doesn't have to be in writing. And that's not really what the Second Circuit said. They said it's better to consider the failure to adopt a good preservation practice as one factor in determining whether discovery sanctions should issue. So what they basically said is, well, we're not going to say that you're going to automatically get sanctions, but you're going to have to defend why you didn't. And the ideas that they said is, what about the one-person company? What about the no-person company? Things like that. They didn't want to have a bright-line rule. So don't think you can rely on the Chin decision to go and say, well, we didn't put a litigation hold out there because we didn't think we needed to, or we didn't put it in writing, we just talked to people. I tell clients, look, if you want to do that, that's fine. You can be subject of the next opinion that's written, and that's what nobody wants. So there's no reason not to put it in writing.
And you don't want to increase your burden.
Yes, exactly, and your costs. Some of the quick questions, people always say, well, what should we put in the thing? And one of the most important things I say is down at the bottom of this slide is do not make it sound like a contract. If you're using therefore and this and whatsoever, if you've got a paragraph-long definition of the word document, you're doing it wrong. You got to make sure that people understand these. A couple of years ago, we got sued by a patent troll over a patent they claimed was on our software. We knew that it wasn't a valid claim, and we fought it tooth and nail, and they eventually agreed to withdraw the complaint. But even though we knew it was complete and utter crap, basically, we still issued a legal hold. We still issued a legal hold to the managers, to the developers that might have been involved in the process, even though, and that's a perfect example of I didn't give them, or, we didn't give them our legal analysis of the claims in that. We didn't say to people, we don't believe this patent is going to have any teeth to it. Because basically if you do that, you're telling companies, or you're telling your employees that they don't need to pay attention. And so if you have businesses that want to put that in, if you've got managers that want to put that in, it's a really bad idea, because you can basically completely just nullify the legal hold if you put that in. You want to make sure it's simple. When we sent out our legal hold, it was in the form of an FAQ. Hey, we're being sued by this company. Hey, here's what you got. Questions like, what do I have to do now? And then answering it. Why are we getting sued? What is what's going to happen? Blah, blah, blah. We answered those, who, why, what, where, when, and underlined in red on the middle of the slide for its importance is the idea of providing a contact person. One of the most important things, make sure that when you're putting your litigation hold together that you give people a contact person to call and ask if they have any questions about the legal hold itself. A couple of quick things. What do you want to do? Some good things to put in there. Tell the custodians to read and acknowledge, to suspend any deletion strategy they may be using. Identify some data locations is always a good thing. That oftentimes becomes part of a custodian questionnaire. You don't want to tell them, you tell them don't delete files, don't copy files, don't move files, don't change anything. Just, don't try to start getting organized and you're going to start altering metadata by moving stuff around. You don't want to do that either. So just some highlights of rules that you can put in there. So that was step 1 and 2. Step 3, 4, and 5 are pretty straightforward and pretty, logical if you think about it. Distributing the legal hold. You can distribute the legal hold however you want. If you want to do interoffice memorandums and little envelopes where everybody has to sign off on it and everything, you can do that. Most companies today do it through email. They'll send out an email to all the individuals with a legal hold notice either in the body of the email itself or in the attachment. Important thing is, however you do it, it has to be verifiable. In other words, you can't just tack something to the bulletin board. You can't just send out an email without something more. You need to make sure that the custodians acknowledge that they have this responsibility. And every software out there that manages legal holds that I've ever seen does this pretty much in the same way, with a big button that says something like I understand or I acknowledge or whatever, and it tracks that information as to when the custodian did it and creates that nice little audit trail for you. The second thing is maintaining the legal hold. You got to send out routine reminders. How often? Really kind of up to your organization, up to the people. Usually we see organizations send out reminders once a quarter, sometimes more often, sometimes less often, really kind of depending on the case. And you want to make sure you're tracking custodians throughout the process. You want to make sure you track and keep in mind when you send out those reminders and when did custodians acknowledge their reminders. And you also want to release custodians if they're not really part of the process anymore. If during the discovery process you realize the custodian doesn't need to be on legal hold, let them go. But make sure you track it. And the last step is the audit trail. Sure.
Let me add one other point on maintaining legal hold. You mentioned don't be afraid to go back to a hold or a custodian list and modify that list from time to time. It's sometimes very appropriate to update the content and the substance of a legal hold as a matter is further defined, as claims change, expand, or what have you. So it's perfectly appropriate and called for to update a hold notice itself with this additional information and requirements for the custodians.
Absolutely. That's a great point. And again, that's something that a lot of the software solutions out there will just help you track version over time and who received which version and who acknowledged the version and when changes were made is something that kind of comes along with that and is the last point about the trail. So just to give you a quick view, this is kind of what we do and how we help our clients see here that kind of the reports include things like not only the matter name, but when people were sent their knowledge, when they acknowledged it, when they got their last reminder, when they got the last kind of acknowledgement reminder. It's an audit trail. Only reason we throw this up here is to kind of show you what our audit trails generally tend to look like. From a report perspective, there's more detailed audit trails, of course, available in a lot of these tools as well. And the second to last slide, we're getting to the questions, so everybody hold on just a little bit. two big questions that we get on the end of a legal hold is, number one, when can I let custodians go? First off, obviously, when the event is concluded, settlement or final disposition, not just a decision, but a final disposition. If you have non-responsive custodians during discovery, you find out that Marion Accounting doesn't have any documents, and Bill in Finance doesn't have any documents, or by agreement. You can. I always say this to our clients, both our law firm clients and our corporate clients, that there are all these requirements in litigation, but you can agree to anything you want to agree to. You can agree to produce e-discovery on stone tablets if everybody agrees to it. And in fact, there have been some rulings out there where the initial, the one party came back and demanded native production of documents, but because the protocol said that the documents are going to be produced in TIFF, they were held to that. There was one ruling, had a lot of press, the judge, I can't remember the name of the case off the top of my head, who said that you can't use predictive coding in this case. And it wasn't because the court didn't like predictive coding. It was because the parties had already agreed to a protocol that specifically did not include predictive coding. And so my point for all of that is
progressive insurance case.
Yes, the progressive insurance case. Thank you, Barry. You can definitely narrow down your list of custodians by agreement. We see clients do that more and more often today. The last thing here, I guess I'll get to the very last one, is the importance of routine reminders. We've already kind of talked about that, so I'll jump forward. Last question is, are legal holds discoverable? There are a bunch of cases here, but we want to get to the questions. So I'll just say generally no. Usually the question of the factual questions, who received a litigation hold, when they received a litigation hold, when they acknowledged their litigation hold, if they were reminded about litigation holds, and what they might have done in response. Like I could ask a custodian in a deposition, did you get it? Did you get a litigation hold? When did you get the litigation hold? What did you do in response to the litigation hold? The actual litigation hold notice itself and any instructions or understanding conversations with counsel about what to do with a litigation hold, those are all advice, those are all work product, those are all protected. Unless, of course, the litigation hold notice itself becomes an issue, and then usually it's an in-camera inspection by the judge. So generally speaking, the answer is no. The actual notice itself is not discoverable. However, and I know, Barry, you've worked with clients on a lot of this, a lot of times you'll see attorneys want to produce this information and actually produce a copy of the litigation hold with an agreement that doesn't constitute a waiver, because they want to show beyond a shadow of a doubt that they fulfill all these obligations. So I have time to answer all the questions, Robin. I know you've been chomping at the bit. You want to let us know what your first question is.
Okay. Is it necessary to put all employees on notice of the issuing of a legal hold versus just the identified custodians? If so, does an Internet posting suffice? If not, have any courts spoken on what steps must be taken to reasonably identify those employees who must be notified? And they sent in a modification to clarify, should we be notifying all employees generally in addition to key custodians specifically of the issuance of a hold?
So there's a lot in there, and hopefully I'll answer it. But Robin, if I miss a part of the question, please prompt me again. I'll take this one, Barry. I think this gets back to the question we talked about of identifying custodians, and it's one of the trickiest things, honestly. The two most difficult parts, and as you can see, the parts we spend most of the time on, is the triggering event, like when do I have to do it, and then who do I have to give it to. The actual content and the monitoring are much more mechanical processes than the kind of art that is deciding when to issue it and who to issue it to. Do not issue it to everybody. You don't want to send out a general notice to everybody saying the company's being. There's no reason to. If you feel like you need to let your employees know that there's a lawsuit against the company to quell any kind of internal rumor mongering or things like that, by all means, yes, address it, let people know. But don't make it part of your litigation hold process. That's more of just general business management, human resources management, things like that. You don't make it part of the formal process. You don't want to include it in that process, because if you do that, then you kind of start down that slippery slope of the boy who cried wolf, and you don't want to go there. And notice, definitely not good enough. Intranet notice, not good enough, unless have a warrant to the custodians that says, you're on the hold, go here, look at it, click a button and tell me you read it and understand it and you acknowledge your understanding. Sure, you could do it that way. But posting an internet on your internet, me would be this is putting the board and the kind of people look at it, you're hoping they do something about it. But, nobody's going to. I think that hit all the points of that question, Robin, unless you missed something there.
It did. When a company has a document destruction policy keeping everything for at least 10 years, does the importance of a document hold decrease?
I'll address that one.
Go ahead, Barry.
If you don't mind.
I know we've had this one come up before specifically, so go ahead.
No, you still have the obligation to issue a hold because that 10-year period is a rolling period, and it's very likely in intellectual property cases, medical device cases, long-term construction projects where the course of execution may be much longer than the time frame. It's critical to issue litigation holds and actually do the proper preservations, which is not a topic of our discussion here. Brian, anything to add?
I would just say that I read a case on this exact point, and the transcript from the hearing before the judge, where the attorney got up and said, Your Honor, my client retains all of their documents forever, so there wasn't really a need to issue a litigation hold. And the judge comes back and says, that's all fine, but what you're saying was you never issued a litigation hold, correct? And the attorney said yes. And so it goes on to talk about it, and there were some sanctions issued, and if anybody's interested in that particular case, you send an email to us, and we'll find it and pull it up and send you the site. But the idea there was it wasn't good enough. Yes, you might store everything forever, but it's not the same as telling people that they can't destroy data, and they specifically have that obligation. Robin, next question.
Many times you don't want to give notice throughout an organization that you're going to file a lawsuit. How do you balance the requirement to issue a legal hold without disclosing that a lawsuit is on the verge of being filed?
That's a really good question. Barry, I'm not sure if you have an answer to it. There comes a point where your legal obligations are going to trump your desire for secrecy. It's not a defense to not doing it that, well, Your Honor, there was a strategy or there was a secret concern there or whatever. At some point, you're going to, once you've made that decision to file a lawsuit, there's a reasonable anticipation of litigation, and there's no defense around a need for secrecy. And so I'd say, although I've never seen a case on point, I'd say that based on the cases that I've read and based on the rules that the courts have kind of promulgated around this, tough luck. You can wait to do it, but you're going to take a risk.
Mm-hmm.
You're going to have to take that plunge at some point in time.
Sure. Are there any recommendations on triggers tied to severity specific to claims typically with insurance coverage, whether it be workers' comp, auto, accident, comprehensive?
Barry, do you want to? I can answer it, or
that's a tough one to answer because if you say that a claim of $5,000 doesn't warrant the issuance of a litigation hold, and that claim mushrooms into something much bigger, and you didn't issue your hold, you're standing out with a lot of exposure, and so the question is, how much risk are you? And it's really an exercise in evaluating risk, and that is something that you need to discuss with corporate counsel, your insurance agents and insurance brokers, and your risk officer to see how much pain you're willing to suffer for not doing what is reasonably anticipated to be done.
Mm-hmm.
And I would just add to that Barry hit the nail on the head. It's a reasonableness standard, right? At the end of the day, there are no bright line rules to a lot of this stuff, and especially there's no bright line rule at all to the triggering events. So it is, what would a reasonable person do? The issuance of the litigation hold and even collection of information the actual data collection process itself to preserve data. I always tell clients those are the cheapest things you will ever do in litigation. Even if you think it's painful, if it's expensive, you're not doing it right. But if you're doing it right, issuing legal holds and actually even collecting data should be some of the easiest steps and cheapest steps of your entire process. And if nothing else, look at it as an insurance policy. It costs you something now, but it protects you later. You may never get the full benefit of your insurance policy, but it's important that you do it. And you go into it with your eyes wide open as to the risks of not. Robin, next question.
Oh, great question. Is it a good decision to collect all employees that are exiting the company, even if they are not on a litigation hold?
That's a good question. And people ask this a lot. Like the question of what happens if we find out that, after Mary leaves the company, 6 months later we realize that she was integral to this particular lawsuit and we didn't do anything. It's, again, a reasonable standard. Was that a good decision, a bad decision to include her or not include her in the first place? That's the court's going to look at, what was your decision reasonable given what you knew at the time? Again, nobody's perfect and nobody's going to expect you to be perfect. I would say this is also kind of one of those things where I'd balance the risk versus the reward, right? If I'm in a company that does a ton of litigation and I've got certain people, managers, executives, especially who are going to be involved in litigations regularly, then I might want to preserve their data after they leave, at least for a period of time, to make sure that information might not be important. But if you're talking about an organization with 100,000 employees and they've got regular turnover like crazy, you can't do it. So it really comes down to a reasonable person. I think what's more important is that you have a process where you've taken the time to look at, what are our obligations and how are we handling exiting employees, and are we making a reasonable decision? Most companies, this is a big black hole. They're not even looking at this issue, or they're caught off guard by this on a regular basis. So I think if you put in a process where you're evaluating exiting employees, and especially if you're looking at key employees, and in different organizations, key employees can be different things. But if you're looking at that and you have a process and you're evaluating it, just because you made a mistake, again, look at the new federal rules of civil procedure. Unless that mistake was willful, you're not going to get harsh sanctions like you do if it was willful. So I think, you want to be able to show the court that we took a reasonable step, that we had a reasonable process in place, and nothing's going to be perfect. But it's so much better to do that than it is to walk in and just say, well, we didn't do anything.
And I want to make one more point on our education site. We've got our second most popular webinar, which is Stop the Leaks, that would be a good resource for those who want to refer to that. I've got a couple of really good questions left, Brian and Barry, and then we'll close out the program. How often does BIA suggest custodians are reminded that they are on legal hold?
Barry, I'll let you take that.
Sure. I think it always depends. We see with many of our clients that custodians are stratified, so that serial custodians, C-level executives who seem to be involved with most litigation are perhaps reminded on a quarterly basis, other custodians on a monthly basis, and that is a decent rule of thumb. If it's not as all litigation is serious, but if it's deemed to have less risk to the corporation, perhaps a quarterly reminder is appropriate.
Okay. And this is our last question, and there's a few parts to it, but how important are custodian questionnaires? Should they be used in every matter or only larger matters? And can custodians be released after all the data has been collected from them? And that will close out our program.
So, with respect, can custodians be released once their data has been collected? I wouldn't do it unless you get agreement from the opposing counsel, because you never know what's going to happen in a case. You never know when something might take a left-hand turn. So, legally, you're under an obligation to preserve documents and preserve data throughout the pendency of a case. Your discovery obligations don't end. You have continuing discovery obligations, and so I think it's a really bad idea to let custodians off of a legal hold during the pendency of a case, unless you get agreement of your opposing party that you both can do that. Especially if the case involves some very well-defined issue that was very specific to a particular point in time, you might be able to get agreement on that. You might even get a magistrate judge to help in a conference to get people to agree to that. But absent that, don't just do it on your own. So that would be really, really risky. And now again, would it necessarily result in sanctions? No, they still have to prove that data was lost, right? But it's a very risky step to take without consent. What was the other part of it, Robin? I forgot.
Hang on a second.
Should we always issue a legal hold, a custodial questionnaire? And in that regard,
yeah, go ahead.
It depends on, again, I hate to say it depends. It's a reasonableness test. How well do you know your organization? How well do you know the individuals that have been identified as custodians? Do you know that you have all of the potential custodians identified? And I would think in most cases that knowledge is yet to be determined. So in more cases than not, we would recommend issuing a custodial questionnaire. They can be relatively straightforward and asking the basic questions. And as Brian mentioned earlier, expanding the net. Who else in your organization do you know that might have information relevant to this matter? Then it doesn't hurt to then issue a second custodial questionnaire if that's appropriate, that has very expansive, detailed questions related to the specific questions of the matter.
Hey, this one.
Yeah, I would just say.
Go ahead. I'm sorry.
Really quick, Rob. I just wanted to add to that is, some people look at the custodian questionnaires as kind of a burden, and we tell our clients all the time you should look at the custodian questionnaires as one of the best tools you have. Not only can you, it's almost required today in some cases because you don't know where data is. Barry touched on that a little bit, the idea of the data's all over the place in the cloud, and that means it can pretty much anywhere. So you got to find out where it is. Custodian questionnaire is one of the best ways to do that. But when it comes to facts too, especially if you got 100 custodians or 200 custodians or thousands of custodians on some cases, there's nothing more efficient than that custodian questionnaire. And it's not just about where's your data. It's about what do you know about the case? Were you at the board meeting on the 25th? Whatever the case may be, you should be looking at the custodian questionnaires as an awesome way to not only define the matter but figure out what everybody knows and define who are the really important custodians in the case. It's an incredibly, incredibly useful tool that we tell our clients all the time that they need to use more and more. So anyway. And
extraordinarily efficient.
This question is too good not to include in our final question. It just came in. If a company has third-party vendors, is it the vendor's responsibility to distribute and maintain the legal holds for its relevant employees, or does the company need to track those as well?
That's a really good question. Something I haven't heard before. I would say based on the cases, there's no kind of delegation of responsibility, right? You have to make sure that it really comes down to you and that other company as to what they're going to do and how they're going to do it as far as maintaining documents and litigation holds. You'd only be serving that third-party company and expecting them to do something, again, if you have control, right? Or possession, custody, or control are the magic words. And so, in the cases we've seen where this issue comes up, it's always been because there was a contract provision or something, and we all know this is probably one of the most common things we see in contracts today, where data is at issue, is it says that, the person who's creating the data owns that data. And so, you can't just imagine you standing in front of a judge and saying, well, Your Honor, I told my accountant that they had to save documents, but they didn't. You're going to get sanctioned if it really comes down to that versus the third party. So you have control, you have the right, you have the requirement to do it. Whether you can actually go in and send those hold notices to the employees of that third party, yeah, that gets into a really sticky issue. But just like most things in the law, just because it's a sticky issue or it's difficult or you don't see necessarily how you can get it done isn't going to resolve you with the responsibility of figuring it out. And so I think, while I haven't seen a case on point, I would expect the court to say, I don't care what your problems are, you got to resolve it yourself. That's your responsibility, and you can't delegate that responsibility to anybody else.
Folks, on behalf of BIA, we want to thank you so much for attending our Knowledge Leadership series of webinars the third Thursday of every month. We look forward to seeing you back next month when we're going to be talking about e-discovery project management. Brian, Barry, thank you so much for your valuable time and talking with us today about the ethics of legal hold.
Well, thank you, Robin, and thank you, everyone, for coming, and hopefully you'll join us again next month.
Don't forget to fill out the survey so you can get your course materials. Thank you so much, and we'll see you next month.